Hi, and welcome to this training video, Competency to Stand Trial. I'm your host, Mark Brennan, and I'm Project Director for Community Support Training at the Missouri Institute of Mental Health in St. Louis, Missouri. I invite you to relax and just keep in mind the following key concepts as you watch this training video. First, and probably the most important of the key concepts, is competency as it relates to one's ability to stand trial. Also, we're going to be looking at determining factors for competency to stand trial, how a determination of incompetent to stand trial differs from a not guilty by reason of insanity defense, the frequency of the IST defense, myths that surround the IST defense, court rulings that impact the defense, competency evaluation. What does it involve? How's it done? What's being evaluated? Who are the key players? Time limitations on the IST defense, length of stay for IST defendants, psychiatric and psychological treatment options for IST defendants, and finally, competency restoration. What does it involve? I invite you again just to relax, keep the key concepts in mind, and also we've attached for your convenience at the end of this training video a glossary of terms. If you use that glossary of terms and also use the key concepts, you're going to glide through the test with no problem. And also this information will be applicable to your day-to-day work life. Thanks and good luck. Now let's talk with John Hurley. Hi, John.
Hello, Mark.
Like a lot of other people, I have some questions about the competency to stand trial defense. And I guess the first thing that I'd like to ask you is, what is a legal definition of competency to stand trial?
Competency to stand trial is a legal concept that consists of two parts. It consists of the defendant's ability to have a rational and factual understanding of the charge or charges against them, as well as the ability to collaborate with their attorney in formulating a defense strategy.
So the individual has to have competence in those two areas.
That's correct. Incompetence to stand trial would be the absence of either one of those two abilities.
Okay.
In Missouri, the competence to stand trial, or incompetence to stand trial, I should say, should also be due to a mental disease, which is a mental illness such as schizophrenia, or a mental defect, which would be a traumatic or congenital condition such as brain damage or mental retardation.
I see. So in terms of a psychiatric disorder as well as like a developmental disability or some other disability that would render you incapable of understanding the charges against you or being able to assist the counsel in your defense.
That's correct. You could have a mental illness or a defect such as retardation or brain damage to satisfy that.
A lot of times people, and I'm one of them, are confused about this not guilty by reason of insanity plea. And how does that relate to incompetent to stand trial, or does it?
Actually, they are two very distinct concepts in the law. Not guilty by reason of insanity is a established defense strategy that can be raised by the defendant as a way to explain their inability to understand the consequences of their actions at the time of the offense, or the inability to know right from wrong. Therefore, it is within the defendant's control as to whether or not that is raised at the time of trial. The issue of competence to stand trial is one that is raised by court personnel that are genuinely concerned and have some doubt about the defendant's ability to understand the charges against them or to assist their counsel.
Even if the defendant insists that he or she knows what he or she is doing?
That's correct. The issue of competence is one that lies outside the control of the defendant.
Okay. And while we're talking about this whole competence issue, can you talk to us about the prevalence of that as a defense?
It's actually less common than many people think, I believe. In about 5 to 7.5% of all cases that come up to be disposed of in the legal process, there is some concern about the defendant's competence to stand trial. At that time, or among those cases, those defendants are evaluated, and of those 5 to 7.5% of all defendants, roughly 16% of that 5 to 7.5% are found to be incompetent to stand trial.
Okay. And you used the term disposed. Can you help us to understand what you mean by that?
Disposed would be any settling of the charges against the defendant, whether it would be through a trial, through a plea bargain, or through dismissal of the charges.
Okay. So if someone were to ask me the difference between not guilty by reason of insanity defense and incompetent to stand trial, what answer would I give and be correct?
You could say that not guilty by reason of insanity is a defense strategy and incompetent to stand trial is not. You could also say that the decision to implement the not guilty by reason of insanity strategy is one that is up to the defendant. It is one that the defendant has a say in whether or not this is implemented, whereas the issue of competence is one that they don't essentially have any control over. It is an issue that is decided for them.
You know, sometimes you hear people talking about how people try to get out of responsibility for crimes that they've committed. That's one myth that I've heard. Are there other myths about the incompetence to stand defense?
Well, I think one of the myths would be that it's more common than is actually the case. If you're looking at 16% of 5 to 7.5% of cases, that's not a very big number. So it's actually comparatively rare. Another would be that, like the not guilty by reason of insanity defense strategy, the issue of competence is one that can be raised by the defendant to explain their state of mind at the time of the crime or since that time.
Okay. And I believe that there was a 1960 U.S. Supreme Court ruling that set a precedent for the incompetent to stand trial. Is that correct?
That's correct. Actually, the issue of competence to stand trial is one that has been a part of the law for quite some time now. But it was in 1960 that the U.S. Supreme Court made a definitive ruling and established the two-prong approach to establishing a defendant's competence to stand trial. As I've stated, the two prongs would be, or the two prongs to this approach would be, one, the ability to have a rational and factual understanding of the charges against them. The second prong would be the ability to coherently assist defense counsel in their defense strategy.
Okay. And there are probably other court cases that have happened that you'd want to talk to us about?
Actually, since 1960, since the Dusky decision, there have been 4 significant court decisions that have addressed the issue of competence to stand trial. The first was in 1968 in Wilson versus the United States. The U.S. Supreme Court ruled that amnesia or memory loss is not an automatic bar to competency to stand trial. The next would be in 1972 in Jackson versus Mississippi, when the United States Supreme Court ruled that a defendant cannot be held as incompetent to stand trial indefinitely, but only for a reasonable period of time, with the definition of a reasonable period of time to be decided state by state. The third case would be Drope versus Missouri in 1975. In that case, the Supreme Court ruled that it takes a bona fide doubt of a defendant's competency for that issue to be raised by a court official, that it can't be raised for another reason not related to competency, for some sort of strategy in order to obtain additional information about the defendant through the court procedure. The court also said in this case that the threshold for a suspicion of incompetency isn't very high. They also said that issues pertaining to mental illness of the defendant can also be raised in this evaluation or through this. The final court case was decided in 1992 in Godinez versus Morin, The court ruled that a defendant found competent to stand trial is also presumably competent to make other decisions about their constitutional rights, such as the right to waive a jury trial or to be assisted by counsel.
It's interesting that when you were talking about amnesia as not being a condition necessarily that would result in someone being determined incompetent. Can you talk a little bit about that?
Well, amnesia involves memory loss, and memory loss does not necessarily preclude a defendant from understanding the charges against them and assisting their counsel in their defense.
And the other thing that you mentioned that I've really not considered was the idea that the incompetent to stand trial plea is not necessarily a terminal one, that there's a condition apparently that you want to get the client to where they are competent. Is that correct?
That's correct. There is a competency restoration. So it is not a terminal or indefinite condition, but one that is ultimately resolved in the vast majority of cases.
So how long could someone be considered incompetent?
Well, the statutes pertaining to this vary from state to state, and much research has been conducted that examines this issue. For example, one study found that the average length of stay for an incompetent defendant was 68 days, though this study also pointed out that average length is likely to vary from jurisdiction to jurisdiction or state to state.
So if the incompetent to stand trial decision changes from jurisdiction to jurisdiction, there must be some kind of evaluation process that occurs. Can you talk to us about that?
That's correct. The evaluation for competency is conducted by a forensic examiner who is typically a psychologist or a psychiatrist. The examinations that I've been a part of have taken place in a state correctional facility, a prison, or in the forensic examiner's office in a state hospital or in a private practice even. This examination involves a thorough interview with the defendant and also quite possibly family members or friends or a spouse close to the defendant. You want to get as much information as possible using direct quotes from the defendant and other parties whenever possible. And the overarching purpose of this evaluation is to determine, do they understand the charges and are they able to assist counsel?
So why couldn't you just ask them those two questions?
Well, it's a lot more complicated than that. You have to really test their knowledge and really test their ability to understand. So you would want to ask them pretty detailed questions about the procedure of the court. You would want to ask, do they understand the charges against them? Can they list the charges against them? Do they know what various court officials, such as the judge, the prosecutor, the defense attorney, actually does? You would want to obtain a pretty careful account of their behavior and whereabouts at the time of the crime. You would want to assess their ability to interact effectively with their defense counsel. And you would also want to determine if they are capable of displaying appropriate courtroom behavior.
And can you talk what that would be?
Appropriate courtroom behavior is, can they attend to the proceedings? Can they offer their counsel feedback during the proceedings about what various witnesses are saying? Can they be respectful? Can they sit still? You don't want a defendant that can't do these or can't accomplish these tasks, because that would interfere in their ability to assist in their defense.
Okay. Let's talk for a few minutes about treatment strategies for someone who is incompetent to stand trial.
There are both pharmacological or prescriptive medication type treatments as well as psychological treatments. Medications can be used in alleviating a variety of symptoms of psychiatric illness, such as emotional and mood disorders, violent and aggressive behavior, and suicidal and self-injurious behavior. Psychological treatments are used to assist the defendant in obtaining information about the court procedure, about their specific charges, about the legal process in general. This can be done either in an individual or in a group format in a psychiatric facility. Individual and group psychotherapy can be used to address any psychological issues or psychiatric symptoms that the defendant may have. And milieu and activity therapy can be used to promote positive interaction, as can social skills and assertiveness training.
And so how do you know when you get that client to that point where their competency is restored? What kind of things are you looking at that will tell you that?
Well, every defendant initially found incompetent to stand trial remains hospitalized until the competency is restored. According to Missouri State statute, each each defendant initially found incompetent to stand trial is reevaluated every 6 months. And during the reevaluation, the examiner again looks at their ability to understand the charges and assist in their defense. Once the examiner is satisfied that this has occurred, they submit a report stating that, and then it is ultimately up to the judge to make a final determination of competency based not only on the forensic examiner's report, but also on other reports or other testimony.
Once an examiner has determined a client to be incompetent, are there other issues that need to be that you need to be concerned with?
Yes, actually there are two issues that need to be addressed. One would be the feigning of psychiatric symptoms in order to avoid punishment, which is a condition known as malingering. The examiner would want to assess for that and to make some comment about the likelihood of either the presence or absence of malingering. The examiner would also want to address the likelihood of the defendant to be restored to competency, make some sort of prediction about when this could occur and how likely this is to ultimately occur. The problem with that would be that there is some concern about the inadequacy of being able to predict when and if a defendant can be restored to competency.
More often than not, someone will be restored to competency.
That's correct.
But there is probably a small percentage of individuals who won't be? Is that what you're saying?
That's correct. Each individual is evaluated for competency that was initially found incompetent, is evaluated for competency every 6 months. If it is found that there is little likelihood that a defendant will ultimately be found competent to stand trial, what will occur is that the charges against them will be dismissed, and at that point, one of two things can happen. One would be that they could be essentially recommitted through the civil commitment procedure, or a guardian could be appointed for them, at which time the guardian could, with the court's consent, could recommit the individual for a period of 30 days.
Okay. And talk to me about how you would determine whether someone was malingering. What behaviors would you be looking at?
Well, you would want to talk to staff that is pretty closely associated with them, that interacts with them. You would want to try to find out if there is consistency in their presentation or inconsistency. If they're acting one way in front of the examiner and another way when they get back to the unit, if they're acting psychotic or depressed or feigning lack of understanding, but then they get back to the unit and they show behavior that contradicts that, that's one thing that you would want to assess for. There are also a couple of psychological tests that can provide information about the likelihood of the defendant's malingering.
So, John, any final thoughts for us?
The issue of competence to stand trial is a legal issue separate from not guilty by reason of insanity. It involves an assessment of a defendant's ability to rationally and factually understand the charges against them, as well as the ability to lucidly assist their counsel in formulating and implementing a reasonable defense strategy. Most defendants found incompetent are ultimately restored to competency, and ultimately their cases are disposed of. While hospitalized, there are several established pharmacological and psychological treatments that can facilitate this process or hurry it along. Most defendants are not hospitalized for an extended length of time. As I pointed out, one study found that the average length of stay is 68 days. Individuals found incompetent to stand trial ultimately have to go back to court. It's not necessarily a get-out-of-jail-free card or a way to avoid what they've been charged with.
Mm-hmm. Well, thank you so much, John, for dropping by and talking with us about this important issue, incompetence to stand trial. I would invite the audience, if you would like to read more about this topic, please feel free to contact the website www.mimh.edu. Thank you.